Blood Money. Article by Anna von Reitz. Part 12. Additional Issues for the International Court of Justice. Pride of Place. Yesterday, 22nd of April 2021, the House of the U.S. Congress, the British-affiliated Territorial Congress, passed House Resolution 51 entitled, "To Provide for the Admission of the State of Washington, D.C. into the Union." The resolution was presented as a bill, and it was voted upon as an enactment of law applicable to the territorial government and its citizenry, not as an amendment to the Constitution of the United States of America. This is important because such an action would require a constitutional amendment, and it would need to be approved by the actual state governments now assembled and in session. Neither did this resolution receive the 2/3 of the votes cast as mandated by Article 5 of the federal constitutions. This is important for obvious reasons. The District of Columbia is a creation of the original federal constitution passed in 1787, which also provided that the federal Congress should provide for its governance and act as a plenary oligarchy with respect to its administration. Quote, "To exercise exclusive jurisdiction in all cases whatsoever over such district as may, by secession of particular states and the acceptance of Congress, become the seat of government of the United States." End quote. Article 1, Section 8, Clause 17. The members of the Congress have no ability to alter or amend this provision of the original Constitution with an enactment of private laws. And also, the actual American government now in session has absolutely no obligation to enroll or accept the District of Columbia as a state. This is important because while the Congress rules as a plenary oligarchy over the District of Columbia, their authority is strictly limited. They can dictate what the District of Columbia desires, for example, to become a state of the Union, but they cannot mandate the acceptance of their dictates by the actual states of the Union. The District of Columbia was created by land cession granted by the states of Maryland and Virginia in the year of 1790. The purpose of this land cession, a special purpose land grant, was defined within the Residence Act of 1790, First Statute 130, described as an act for establishing the temporary and permanent seat of the government of the United States. Apart from this use, there is no grant of land provided for, nor any reason for the District of Columbia to exist. By operation of law, if it does not serve this defined purpose, the land reverts to the actual owners, Maryland and Virginia, and once again becomes part of those states. As the Congress of 1790 defined the purpose of this cession of lands as being for the establishment of the seat of government of the United States, no future governments have the authority to change the terms of the land use, nor any authority to take possession of that land for the purpose of establishing any additional states of the Union. The most that the members of the Territorial Congress could do upon the dissolution of their international independent city-state would be to honorably retrocession the land back to Maryland and Virginia, provided that the actual states accepted the land back. This provision is important because the land that is subject to retrocession may be polluted or otherwise damaged, and the states have the right to inspect the premises and decide the terms upon which they may accept it back. As the District of Columbia was, moreover, created by the combining of lands from two distinct states of the Union, the action proposed to arbitrarily take lands belonging to these states and combining these lands without the express consent of the legislatures of these states, their state assemblies, is beyond the powers of any U.S. Congress. Maryland and Virginia gave secession of the land underlying the District of Columbia for a specific purpose. These states of the Union never severed their jurisdiction over those lands. They merely gave up their authority to legislate over cases arising within the boundaries of the District of Columbia. This is important as it concludes that the independence of the District of Columbia is as an inchoate state, not an actual state. Please also observe that the grant of what amounts to a perpetual land use permit by the states of Maryland and Virginia does not provide for any other use of that land, such as the actions taken to create an independent international city-state known as the Municipality of Washington, D.C. Such a use of the land as the headquarters of an independent international city-state was never allowed by, nor contemplated by, Maryland or Virginia when making the cessation, and the development of the Washington, D.C. municipal city-state must be viewed as an unconstitutional and non-contractual usurpation against the actual expressed intent of the land cessation provided by our states. Please also note that the District of Columbia is not a possession of land by the United States, but is a grant of land use by the states of Maryland and Virginia, and as such is neither a territory nor other property that may be disposed of by the Territorial Congress under the authority of Article 4, Section 3, Clause 2. The creation of states is not an action congruent with the disposal of lands. In this, as in so many other actions undertaken by our erstwhile territorial employees, they arrogantly overreach the limits of any natural or granted authority and attempt to dictate the prerogatives owed to others. While we most earnestly desire the understanding and support of the other nations of the world and are united in our desire to see a peaceful transition of power and asset control back to the actual American government, this present action by the Territorial Congress is emblematic of the ignorant, reckless, and misguided misadministration this country has suffered at the hands of our paid employees. They appear not to understand the basics of law and history, nor the limits of their delegated powers. They and the principals using them are constantly trespassing upon us in violation of our treaties and commercial service contracts, promoting criminal impersonation schemes, voting themselves raises and emoluments out of the public purse, and committing crimes of various and sundry natures on our shores without any provocation by their loyal and long-suffering employers. To say that their behavior has been wrong-headed and misdirected in gross breach of trust and commercial service contract is mild. In the course of conducting their mercenary war against each other, they have played both ends against the middle, their actual employers. Despite having been given explicit and repeated due process informing them of their dereliction of duty and also the criminal aspects of their misadministration, they have continued to presume upon us and to promote self-interested conflict on our shores. They have continued to evidence a deplorable lack of respect for the public law and international law too. It is apparent that both of these organizations and their attendant municipal corporations are ultimately owned and operated by the Holy See, which through the organs of the British Crown Corporation on one hand and the Vatican City government on the other, has unjustly enriched itself, and the colluding British government as well as the American-born bad actors who have usurped upon their employers in breach of trust. We have, for example, been able to track the receipts from the so-called birth certificate bonds, actually clearinghouse certificates, from the Bank of New York Mellon to the Vatican Bank, to the Bank of Canada, and the rest going to the Federal Reserve banks involved in this criminal fiasco, predicated on the Roman civil law and the continued practice, under that law, of both peonage and enslavement. That this scheme and others like it, including their present pretension of power to declare the District of Columbia a State of the Union, have been allowed to flourish under the storefronts provided by such institutions as the Roman Catholic Church and the United Nations Organization, is a testament to the enduring and arbitrarily coercive power of money and the temptations of falsehood. We have in recent days demonstrated that all the various courts in this country, except for our own, have been operated as identifiable commercial enterprises, secretively engaged in privateering and the collection of war reparations from people who have been at peace since 1814. We have also demonstrated that all the various district courts operating in this country are in fact parish courts operating secretively under ecclesiastical law, popularly known as the Spanish Law of the Inquisition, that has nothing whatsoever to do with our general public. We have had to repeatedly and in public rebuff the Incorporated Roman Catholic Church to inform the respective archbishops that we are not members of any incorporated church, and we have also had to serve similar notice of non-membership and non-participation on the various political parties, Republican, Democrat, Independent, and so on, that presume that we are members of their organizations and that we are voluntarily participating in their devious substitution of private corporate elections for actual public elections. For those of us in a position to appreciate the irony, this is precisely what started the first American Revolution. Americans being forced to pay for the British expenses of fighting the 7 Years' War, which ran from 1756 to 1763, and which is deceptively called the French and Indian War in this country. That and our resistance to the King's Equity Law, a venal admixture of British common law and admiralty law serving as a sugar-coating for legalized banditry by the British royals. Imagine our dismay and disgust to return to our shores, having never knowingly, willingly, or voluntarily vacated them, to discover that our estates have been mothballed as state trusts operated for us by foreign employees, and our people have been press-ganged in diverse world wars and mercenary conflicts, and our babies have been misidentified as British territorial persons and trafficked offshore, where their infant decedent estates have been created and administered under the Spanish law of the Inquisition. What possible insanity is this, and what excuse may the other principals guilty of defrauding our country offer? When did the Americans fail to support the Pope in any humanitarian effort? Did we not offer the Roman Catholic Church a safe refuge of religious freedom on our shores? When did we tax the Church on its extensive holdings? At what point and upon what cause did our actual government ever deserve such disservice at the hands of the Roman Catholic clergy? As for the governments of the Queen and Westminster, where would they be without the Americans saving their bacon in 2 world wars and endless other mercenary conflict squabbles that the British Crown Corporation and its affiliates like BlackRock Inc. and yes, the UN Corps too have engaged in for profit? Our honorable solidarity has been misled, and our armed forces have been misused as cheap mercenaries, a fate that is now being brokered and transferred to the Chinese military. Our international land jurisdiction, as well as our jurisdiction within the international jurisdiction of the sea and in global commerce, has been trespassed upon and commandeered by our own employees under the direction of the Queen, the government of Westminster, and ultimately the Holy See. This has been done in violation of both the Geneva Conventions and the Hague Conventions. And now they propose to clothe themselves with the protections of an American State of the Union without our permission? As neither a territory nor a possession of the United States, the respective corporations, their officers, and the citizenry of the District of Columbia are homeless, stateless, and purposeless unless they immediately yield to the public law of this country and our long-published law of the land. A nationwide educational effort is being made at this time to fully disclose the various political statuses available to Americans and the responsibilities of each kind of citizenry, so the people may freely and mindfully choose and exercise their political status options. We express our undying thanks to our senior American researchers who wish to remain unknown, but who have contributed so long and faithfully to this effort. Anna Maria Reisinger, Fiduciary of the United States of America.